everyone, my name is Ann Stephanie Lejano, BSBA HRM 3103, and yung report ko ay continuation ng legality of strike. Mention has been made earlier of the executory nature of an order of assumption or certification. Even during the pendency of a motion for reconsideration or any question regarding its validity, such an order being mandatory in character, any defiance thereof is illegal. Such defiance amounts to violation of an existing injunction. Number 4. Even if the strike is valid because its objective or purpose is lawful, the strike may still be declared invalid where the means employed are illegal. This is true even where, in addition, all the procedural requirements of the law have been complied with. This is because to be valid, a strike must be pursued within legal bounds. The Constitution itself, in guaranteeing the right to strike, gives the admonition that it should be in accordance with law. In the four-cited AIUP case, the Supreme Court stated that there are limits for the exercise of the right to strike. Among them, the prohibited activities under Article 279, particularly paragraph E, which says that no person engaged in picketing shall commit any act of violence, coercion, or intimidation, or obstruct the free ingress to egress from the employer's premises to lawful purposes, or obstruct public thoroughfares. Indeed, the said acts are the only ones among those prohibited under Article 279 which can be considered for the purpose of declaring a strike illegal as to the means employed in conducting the same. Since they are the only ones that pertain to strikers or those engaged in picketing usually accompanies a strike. However, there can be a strike without any picketing because the latter is not a part of the definition of the former, or necessary element thereof. There can be picketing without a strike if there is no work stoppage and the picketing is done by the employees during non-working hours. Illegal acts during a strike are mostly associated with picketing, which refers to the activity of strikers whereby patrols are placed at or near the place of employment, and these patrols employ placards, a speech, and other means of communication to make known the existence of a labor dispute, to persuade other people to cooperate with the strikers by not dealing with the employer during the pendency of strike. The means employed are communication and persuasion. Other authorities describe picketing as a marching to and from at or near the employer's premises, usually accompanied by banners and other signs by which the strikers make known to the public their dispute with the employer. It is said that it has to be a marching or moving picket, because what is being exercised is the pedestrian's right of passage. An unmoving picket across the employer's gate or on a street is illegal picketing if it effectively obstructs free ingress to and egress from the employer's premises for lawful purposes or obstructs a public thoroughfare in violation of Article 279E.
The prohibition
In this paragraph is directed against persons engaged in picketing because it is in the conduct thereof that the prescribed acts are most likely to happen. The picket line, more than the bargaining table, is the true arena of labor management conflicts. Consequently, picketing as part of constitutional freedom of expression and as a legitimate weapon of labor is a protected activity if it consists of inducing workers or third person through fair persuasion to withhold dealing with the employer. It does not include molestation or physical harassment, actual or threatened physical harm, and material and fraudulent representations. In fact, picketing may be a nuisance if it constitutes an obstruction to the free use of property so as to substantially interfere with the comfortable enjoyment of life or property, or if it constitutes an unlawful obstruction to the free passage or use in the customary manner of a street. It is settled doctrine that strikers are not allowed to picket innocent bystanders or neutral parties, that is, establishment and persons with no industrial connection to the labor involved in the strike. such as those that share common premises or a common passageway with the strike-bound company and who are adversely affected by the picketing of the strikers. Such neutral parties are entitled to be insulated from the industrial action so that the sphere of communication or demonstration may be confined or localized to the parties to dispute. The remedy of injunction under the rules of court applies. This is not a labor injunction, which the labor code prohibits the regular courts to issue, because there is no labor dispute between the strikers and the neutral parties. But where the parties involved in the industrial activity are the labor disputants themselves, the court should adopt a hands-off stance because they have no jurisdiction to act on labor cases or various incidents arising therefrom, not even where the nature of the business of the strike-bound firm requires close attention, for jurisdiction is vested by law and not by the demands of emergency. The banners and similar materials used in picketing must not carry untruthful messages or statements. These are not constitutionally protected free speech that render unlawful the picketing activity. Number 5. A strike is also illegal if declared in violation of a law that prohibits it, such as strike by government employees or those embraced by the civil service, including those employed in the different government-owned or controlled corporation with their own charters. The prohibition is found in the rules and regulations governing the right of government employees to self-organization, which provide, among other things, as follows. The terms and conditions of employment in the government, including any political subdivision or instrumentality thereof, and government-owned or controlled corporations with original charter, are governed by law and employees therein shall not strike for the purpose of securing changes thereof.